Afternoon. Welcome to the commencement for the Yale Law School class of 2025. And before they sit down, I just ask all of you to stand and give them a huge round of applause. Now please be seated. Before we turn our attention to the graduates today, I want to begin by thanking the families and friends joining us today who've traveled from across the world to witness our graduates' journey across this stage. While every student traveled a unique path to arrive here, none of them walked it alone. Every one of you in the audience was won by one of our students' side at some point along the way. For some of you, it was when you encouraged our students' bookishness as kindergartners or held their hands as they applied for college. For others, it came later. For example, when some of you supported the many remarkable veterans in this class during their deployments. Some of you answered the phone when our students were having moments of self-doubt after their first cold call or their first law school exam. And when you heard, "I can't do this," you knew better. Your voice, your encouragement, your love propelled all of our students to this day. We are keenly grateful to all of you in this room that you provided that love and support, even more so because we know that every single one of you had to put up with the most argumentative creatures on the planet. So on behalf of every member of this faculty, thank you for the gift of these students. And to my students, please join us in celebrating your friends and family. I am incredibly grateful to the people who made sure that the journey was worth your while, our phenomenal staff for tending to every detail to make this day special, as they do for our community every day, to our faculty, who with their brilliance and care demonstrate why they are not only world-class scholars, but world-class teachers, and to Dean Guido Calabresi, who is with us today and made the sun shine. The best advertisement for our faculty's success is sitting right in front of me, the members of the class of 2025. It is so good to see all of you in one place. Yale Law School is small by design, but during your time here, you were running in countless directions and racking up extraordinary feats as individuals. But what creates the real magic of this school is the alchemy that results from your being together. It takes a team to go up against Harvard in club basketball. It takes a company to put on a production of Yicked. It takes classrooms full of peers to foster a brilliant discussion, and no clinic ever succeeded by having students work alone. As a community, as a family, you have tested out your ideas, ferociously represented clients, and breathed new life into the public conversation with your writing and advocacy. And along the way, you've helped support the classes behind you as TAs and COCers, student directors and student group leaders, friends and mentors. The example that you set with one another, one of genuine warmth and engagement, is a model for the students who will sit where you do in the coming years. This place is better today than the moment you all first walk through the doors, and for that, I thank you. Now, this is an uneasy moment to enter the legal profession. Fundamental commitments of the profession are being tested. Our democracy is under enormous stress. We taught you to question everything, but I'm not sure if we expected we would all be questioning so much ourselves at this moment. But here is what I know. The rule of law matters because the law is powerful. It allows individuals to stand on equal footing with their government despite its fearsome power. And whether you are a party in a courtroom or a lawyer for someone in need, whether your preferred side wins or loses, a functioning legal system is the bedrock of a democracy and protects us all. The law's power means that you are powerful. You are ready for this moment. Legal training is not a hollow power. It is not a tool you should lend readily to the highest bidder. It comes with an ethical valence and a civic responsibility. The very first words of the American Bar Association's model rules of professional conduct tell us as much. They assign the lawyer not one role, but three. When your degrees are officially awarded and you pass the bar, you will be a representative of clients, an officer of the legal system, and most importantly of all, a public citizen, having special responsibility for the quality of justice. That fundamentally noble mission of the lawyer has long held us steady. It is a mission of service deeply embedded into the bones of this place. And as you go into the world, carry on our best traditions. Serve others. Do right by the law. Do right by yourselves, and the rest will come. But your obligations to the world begin tomorrow. Today is just for you. Cherish the celebration with your friends and your families and your teachers. Now that your casebooks and laptops are closed, take stock of all that you know now that you could not have known when you first walked through our doors. And most importantly, relish this chance to be with one another. The class of 2025 will work in different parts of the world, different parts of the profession, even outside of it. You'll be on different sides of cases across different parts of the country and everywhere else. But you will always be there for one another. And the people who constitute this place will always be there for you. In gratitude for who you are and who you will be, I ask everyone in the audience once again to stand and give you the applause that you deserve. So I am happy to say that the class of 2025 has already come together to participate in a modest act of democracy as part of this commencement ceremony. It is a tradition of Yale Law School that every year the graduating class elects by popular vote one of their favorite teachers to deliver an address. And this year's graduates have elected Eric Brunstad. Eric has taught bankruptcy and secured transactions here as a visiting lecturer and senior research scholar since 1990. In that time, he has taken part of one of this institution's most cherished traditions because every semester we call on the talents of outstanding scholars and practitioners to come and teach our students as visiting faculty. And today, Eric joins the rank of another visitor, the legendary Stephen Bright, in delivering this address. Now, you might be a little bit surprised that the students have selected someone who teaches bankruptcy, secured transactions, negotiating secured transactions, the history of secured transactions. But as any one of his students will tell you, Eric has a magical ability to make seemingly dry materials sing, and a head-spinningly complex issue stand still. He never loses sight of the fact that his subjects are not just about intercreditor agreements or fraudulent transfer recovery, but what happens when people hit rock bottom. Eric is beloved by his students because he is as kind and a devoted teacher as you will find. He's also, as his students know, a poetry enthusiast. Among his course offerings is an entire reading group about law and poetry in which he begins every class with a poem, just a little bit of beauty to remind us that the world is bigger than the classroom. When Eric isn't teaching, he keeps busy at his day job as one of the nation's leading bankruptcy lawyers. He blazed his own trail to build a Supreme Court practice from Hartford, Connecticut, all the while maintaining his specialization in bankruptcy law, bucking the modern trend towards generalist practices. He has argued 11 cases before the Supreme Court. He has been appointed by the Chief Justice to the Committee on the Federal Rules of Bankruptcy Procedure, and his scholarship on bankruptcy law has been cited by courts at every level. Eric is, in short, the very model of a scholar practitioner. Please join me in welcoming him as our speaker for the class of 2025.
Congratulations to the class of 2025. I'd like to begin with a couple of questions and a story. To the graduates, how many of you have had to explain to family members what it is that you have been doing here at the Yale Law School these past several years? To the parents, how many of you have ever been asked by your children what it is that you do for work? When my oldest was a little boy, he asked me, "Dad, you leave in the morning and you come back in the evening, sometimes a bit grumpy. "What is it that you do all day?" I replied, "Well, sometimes I argue in court." He interrupted, "You mean like you and Mom?" And I thought for a moment, and I said, "No, sometimes I actually win arguments in court." So the next time I had an argument in the Supreme Court, I brought him along to watch. After I was done and the justices had left, he ran up to me. I asked him, "So what did you think?" He said, "Well, you were great, Dad, but I don't think they were agreeing with anything you were saying." I said, "Why not?" I asked. He said, "Because they were shaking their heads no the entire time you were arguing." Sure enough, I did not win that one. But like all the times I have lost, I got to thinking about it. Funny how it is when we are not successful. That is when we tend to be more thoughtful and reflective about what it is we are doing. We start to think about how we can do better, and to do better, we have to imagine what that might look like. We have to imagine what a solution to the problem of failure might look like. Which brings me to the first thing I want to talk about, the power of imagination in solving problems. After all, much of what you have been learning here is how to understand how law addresses a host of social problems, and what you will be doing as lawyers is solving legal problems, or at least trying to solve them. And what I want to suggest is that the importance of imagination in that endeavor, which brings me to a poem by Rainer Rilke. You knew there was going to be poetry, which I would like to read in part. It's Archaic Torso of Apollo. "We cannot know his legendary head with eyes like ripening fruit, and yet his torso is still suffused with brilliance from inside, like a lamp in which his gaze, now turned to low, gleams in all its power. Otherwise, this stone would seem defaced. Beneath the translucent cascade of the shoulders, it would not glisten like a wild beast's fur, would not, from all the borders of itself, burst like a star. For here there is no place that does not see you. You must change your life." More than anything, this poem is about imagination. It was inspired by a lump of rock in the Louvre, a torso without arms or legs or a head. So how is it that we can see the great beauty in this and be so inspired? It is through the imagination, and Rilke tells us that this is transformative. We can imagine what is beautiful, and with that comes a responsibility to change your life, to become what you can imagine. This is what I want for all of you, to imagine your best life, to imagine what you can accomplish with what you have learned, and to become your best selves. How do we navigate that? Again, Rilke offers an answer worth considering. As once the winged energy of delight carried you over childhood's dark abysses, now beyond your own life build the great arch of unimagined bridges. Wonders happen if we can succeed in passing through the harshest danger, but only in a bright and purely granted achievement can we realize the wonder. To work with things in the indescribable relationship is not too hard for us. The pattern grows more intricate and subtle, and being swept along is not enough. Take your practiced powers and stretch them out until they span the chasm between two contradictions, for the God wants to know himself in you. After all, that is what you have been doing during your time here, and what you will continue to do. Take your practiced powers and address the conflicts and contradictions you encounter. This is not too difficult for you, no matter how complex. And being swept along will not be enough. No, let your lives be inspired by your imaginations and use your talents to pursue what you know to be good. Another story which brings another lesson. A lawyer was making his very first argument in the Supreme Court. It was a case about state action. During the argument, Justice Stevens, who was a master of the hypothetical, leaned forward and rattled off a narrative about an airport administrator performing various responsibilities. He then asked the lawyer, "Would that be state action?" The lawyer froze, gazing up at Justice Stevens like a deer staring into the headlights. Coming to the lawyer's rescue, Justice Scalia leaned forward and said, "Counselor, the answer you want is no. The lawyer looked up at Justice Stevens. No, Justice Stevens. Justice Stevens, with a Cheshire cat grin on his face, leaned forward and said, why? The lawyer looked up at Justice Scalia, who smiled and responded, Counselor, you're on your own. But we are not entirely on our own, and the lesson here is the why. As you have learned, it is not enough to have an answer simpliciter, not if you want to really grasp something. What is necessary is to understand the why behind the answer. And the ability to question answers you are given. Once again, being swept along is not enough. Always there is the looming idea, why must it be so? And with your imaginative powers engaged, always there is the quest for still better answers. I would like to pause for a moment and single out two aspects of your experience here that are, I think, worth emphasizing. The first is the power of teaching. The second is what we as teachers learn from you. An example of the power of teaching. This year, Professor John Langbein taught his last class on the history of the common law. He will be missed. Among the many things I learned from him is the explanatory power of history. And what an amazing gift that is to understand where things come from. But there is more. The poet Rumi writes, we are the sweet cold water and the jar that pours. Such beautiful language. But what does it mean? Rumi explains, this body existence is a jug. Understanding is water. Rumi reminds us that in all the things we encounter, there is a surface reality and then there is something deeper. Something that flows from the past into the present and then again into the future, and that is real understanding. What teaching offers is just that, the potential for real understanding. Not just in some rote way, but with a greater appreciation for the why of it and the possibilities. It is understanding that animates what we learn and inspires us to even greater understanding. Teachers like Professor Bill Eskridge know this. More than anyone, I learned how to teach from him, how to orchestrate visual presentations with dialogue and real engagement. Besides, he does a truly mean Justice Breyer. Who knew? I could go on with many other examples, but you know what I mean. Then there is what we learn from you. Perhaps the most important is the constant process of renewal that each year brings. It is one of the paradoxes of teaching that every year I seem to get older, but you all stay the same age. One thing that teaching entails is that you never really understand something until you have to explain it to somebody else. The process of elaboration, done reflectively, also brings greater understanding. That, too, is a gift. We also have the gift of just being associated with you. One of you who will remain nameless, Fred, took 6 subjects with me, condolences, but each one of you lent your thoughtfulness to us, and that in turn is also immensely inspiring. So I want to thank each of you for sharing with us your time and experience and insights, and I hope for each of you much success. Borrowing again from Rumi, I hope for each of you that you will unfold your own myth. And to help with that, I would like to offer the best advice I ever received. Of course, it comes from Guido. When I first started teaching, Guido was dean. My first meeting with him was in his office on a bright sunny day. As we sat down, he offered me some sherry. Well, I thought, there goes the rest of the afternoon. It felt a little bit like being in the garden of the Vinci Contini. But here is the advice. I am, of course, paraphrasing. The key to happiness lies in 3 things. First, engage yourself in work that you find to be truly meaningful. Second, figure out how to be at peace with yourself and the world. Third, find someone you love, who loves you back, with whom you can share everything. It has been a great privilege and blessing to have been a part of your experience here. I wish all of you the greatest happiness. Thank you.
So you just took part in an old tradition. One of our newest traditions for this commencement is when I began as dean, which is to invite someone from outside of our walls to help us send off the graduates. And I can think of no person better equipped to do it in this moment than this year's guest speaker, Elizabeth Prelogger. Now, the law students in the room know Elizabeth as she appears on the Supreme Court transcripts as General Prelogger. Elizabeth holds that title by virtue of her last job from 2021 to 2025. She served in our country as the 48th Solicitor General of the United States, a position referred to as the 10th Justice because of the trust the justices invest in that role. Since leaving government in January, Elizabeth has taught a course on the Supreme Court at her alma mater, a somewhat unknown school slightly north of here that beat us in basketball this year. Elizabeth has argued more than 30 cases in the Supreme Court. If you listen to just a minute of any of them, you will understand why she is, by wide acclamation, one of the finest lawyers in the country. It is a marvel to hear her deliver precise, innovative, and compelling arguments with the mind of a professor and then defend them with the reflexes of an Olympian. And like Olympic athletes, Elizabeth trained for years to execute her skill in perfect minutes and seconds. When she was one of you, she was a legendary moot court competitor, a cause so dear to her heart that she used to draft fictional problems for the Harvard Ames moot court competition 10 years after she graduated. Then there were her clerkships with then Judge Merrick Garland on the DC Circuit, with two justices, Justice Ruth Bader Ginsburg and Elena Kagan on the Supreme Court, her career years as an attorney at the Department of Justice, 2 stints in private practice. So undeniable was her preparation for the Solicitor General role that in this polarized political moment, 12 former Solicitors General of both parties supported her Senate confirmation. And some 6 of her former Supreme Court clerks, as opinionated and argumentative a bunch as you will ever find, agreed that she possessed, and I quote, the intellect, temperament, character, and talent necessary to excel as Solicitor General. Elizabeth has another gift, too. She brings an ability to connect high-level legal questions to on-the-ground realities. It is a skill she honed as a self-published poet at 14 while in Idaho, as a journalist in Russia, as a creative writing student in Scotland, and it is one that has served her well as the Supreme Court. As Solicitor General, Elizabeth argued cases with some of the most profound stakes for untold numbers of Americans. They span the future of our tax system, access to reproductive health care, the role of administrative agencies, and the right to vote. Now, I've only described part of Elizabeth's former job, the public-facing part. For much of the day, she was a diplomat within the United States government, strategizing about litigation and providing advice across its parts. And this, too, was familiar terrain. Even as a teenager, Elizabeth was a counselor in high demand. After she graduated from Boise High School as a star student, the Idaho Statesman asked her for tips for success. Just try, Elizabeth said. Put frustration aside. If you take hold of what is there and try, doors will open. And again, a special skill in Washington, she has put frustration aside. She's taken hold of the facts and law that were there and enlivened them with talent and preparation, and no matter what the odds, she has tried, often winning, but never winning for winning's sake. Instead, she has fulfilled her responsibilities as a lawyer, as a true public citizen who dedicated her life to advancing the quality of justice. Our country, our laws, our profession, our world's better for it. She upholds the finest values of this institution despite not having graduated from it, and the finest values of this profession. Please join me in welcoming Elizabeth Prelogger.
Thank you, Dean Gerken, faculty, staff, family, friends, and most importantly, graduates of the Yale Law School class of 2025. Congratulations on this tremendous achievement. Class of 2025, you've earned this degree, or at least I think you probably will have earned it in a week or so when your degrees are actually conferred. Just think about all of your hard work in law school, You've highlighted your way through hundreds of cases and created mountains of outlines. You worked late into the night on papers that I'm told are perplexingly called saws and subs. Many of you accrued and subsequently worked your way out of paper debt. You forged lifelong bonds with your peers in class, clinics, and recruiting events where at least you got to eat a lot of free food. With effort, commitment, and each other, you've reached your destination and a new beginning. Each of you should be incredibly proud of what you've achieved here. Take some time to celebrate and to thank your families, loved ones, and mentors who helped get you to the seat you're in now. It's an honor to have the chance to speak with you, and I've put a lot of thought into what advice I could offer you today. You've already managed to do one thing I didn't do, get into Yale Law School. This fine institution waitlisted me, although I kind of like to tell myself that's Yale's bad. As I considered what advice to give, I knew I wanted it to be applicable to all of you. And that presents something of a challenge because the thing I know best, arguing cases in the Supreme Court, is a relatively narrow slice of legal practice. Plenty of you will enjoy wildly successful legal careers without ever staring down a panel of 9 justices. There's a whole world of lawyering that never touches the Supreme Court. And if Yale Law's reputation has any truth to it, then I understand many of you might not bother to practice law at all. But the more I thought about it, the more I came to realize that everyone has something to learn from oral advocacy. So what I'm going to do today is share with you my 5 rules for oral argument, and my hope is that you'll find these are pretty decent rules for life, too. Rule number 1, take charge of what you can control. When I was a law student, I used to find it a little annoying when successful people would describe their careers as a series of lucky breaks. After all, that didn't provide a useful 10-step plan to try to follow in their footsteps. What I've learned over the years, though, is that those people had put themselves in the position to take advantage of those lucky breaks when they came. In other words, they prepared. It's like the old adage, the harder you work, the luckier you get. And that is the number one way to maximize success in an oral argument. The very first place this comes up during a Supreme Court argument is at the beginning. Advocates are guaranteed 2 minutes of time at the start of the argument to make opening remarks. After that, it's open season with the justices asking rapid-fire questions. But the intro is a time when you have complete control, no interruptions. So those 2 minutes are precious. Before I walk into oral argument, I agonize over my argument, and I make sure that I know that opening cold. One way I perfect my openings is by trying them out on my kids the night before argument. We always have a family dinner together, and I deliver my intro at the dinner table, and then my kids rate me on a scale of 1 to 10. Now, one of the first times I did this, I was arguing a statutory interpretation case, and my intro emphasized a simple point. The relevant provision of federal law used the permissive word may, but the lower court had wrongly interpreted it as though it were a mandatory shall. After I finished my intro, my older son, who was 10 at the time, said, "Mom, you sounded really professional. When you said the statute said may, I really believed you. I bet the justices will look at it and it really will say may." And in fact, the statute did say may, so I knew I was off to a good start. He gave me a score of 10 out of 10. Then my younger son, who was 8 at the time and always likes to one-up his older brother, said, "I give you an 11 out of 10. That was amazing." He went on to explain, though, that he hadn't understood anything I just said. So I asked him, how did I get an 11 out of 10 for an evidently incomprehensible argument? And in the words of my younger son, wise beyond his years, I received such high marks because, quote, "We're a family and we support each other." Not even a Solicitor General could argue with that. There are a lot of things in life you can't control, but for those you can control, it helps to prepare with 11 out of 10 effort. And that brings me to rule number 2, stay loose and trust your hard work. The best way to prepare for oral argument is to think of everything the justices might ask you. But at the podium, you have to be nimble and responsive to whatever they throw at you, even if it's not what you expected or prepared for. I learned this the hard way during my first argument in front of a Supreme Court justice, which was actually in law school in the final round of the moot court competition. Justice Scalia was presiding and was legendary for being a tough questioner. I had poured myself into prep, but I was still anxious as I walked to the podium because it's impossible to anticipate every twist and turn in an argument. And sure enough, Justice Scalia cut me off early in my argument with a question I didn't expect. I had just used the word comparator, and he broke in to say, "Comparator? I never heard that one before. Is that a word?" This is a guy who has used terms like jiggery-pokery and argle-bargle and opinions, but I'm not going to mince words here. The courtroom erupted in laughter, and my mind reeled as I'd wondered whether I just fumbled the English language in front of my whole school. I had to wing an answer, so I assured Justice Scalia that I was pretty sure it was a word, though I have to admit, in the moment I kind of had my doubts. And then I had to adjust for the rest of the argument, trying to excise the word comparator from my vocabulary. Just for the record, I looked it up recently, and comparator has been used in over 10,000 federal cases, including a dozen Supreme Court majorities and dissents, and one opinion joined by none other than Justice Scalia, but who's counting? As an oral argument, so in life, there will always be moments that knock you off your script. But trusting your preparation and being willing to roll with whatever comes your way is where the fun happens. And the thing is, putting yourself in uncomfortable situations like that gets easier over time. I've now argued 35 times in the Supreme Court, and none of those arguments has made me as anxious as that very first moot court in law school. There's absolutely no comparator. On to rule number 3, prize your integrity. Another lesson from oral argument that applies equally in life is that integrity matters above all. After I graduated from law school, I eventually made my way to the Solicitor General's office as a career attorney. When I was preparing for my first Supreme Court argument, one of my mentors gave me some solid advice. He told me, "It's your first argument, so no one expects it to be very good. All you have to do is make sure that you don't say anything so wrong that the Solicitor General has to file a correction letter." Now, I have to say, now that I've been Solicitor General, I really appreciate that advice. It's never fun for the SG to have to send that kind of correction letter. But if we got something wrong, that's exactly what we would do. At the SG's office, we worked hard to be honest brokers and safeguard our integrity. The federal government is the quintessential repeat player in the Supreme Court, participating in most of the court's cases. If we wanted the justices to trust our representations and rely on our briefs, we had to be fair in our characterization of the record and faithful to precedent. We had to turn square corners with the court. You'll soon find that the legal profession ends up feeling pretty small, and that makes you a repeat player with the people in your professional orbit. Luckily, your missteps won't always require filing a formal correction letter with the court, but they do require acknowledgement and an attempt to make things right. Your reputation is your most valuable asset, and it can be the hardest to repair if you don't actively maintain it. Now, here's a related piece of advice. You may have noticed that during oral argument, Supreme Court advocates address each other as "my friend." That habit always makes me smile because at oral argument, you usually refer to opposing counsel as "my friend" right before you set out to utterly destroy their argument and expose its central flaw. But the way you pursue your advocacy and the tone you take with others matters. Be kind, and never, ever be rude to a paralegal, not just because they're essential members of your team or because it's important to treat everyone with respect, but also because they know where all the bodies are buried in your brief. Okay, rule number 4 is distribute your quills. Since its earliest sessions, the Supreme Court has placed a set of white feather quills at each counsel's table for oral argument. The quills are souvenirs, a memento in recognition of the hard work that goes into preparation. So why are there several for each advocate and not just one? Because no advocate works alone. We work side by side with our team, and we distribute those quills to those people in recognition of their effort. In life, you might not have a personal supply of quills to give to the people who support you, but the key is to find your team and show them gratitude. One of the most challenging cases I've worked on was a case last term called Moyle versus United States. The case concerned EMTALA, the federal statute that requires hospitals to stabilize emergency medical conditions. The question was whether EMTALA preempted Idaho's ban on abortion in circumstances where a woman's health is gravely endangered by an emergency pregnancy complication. The United States filed suit and won a preliminary injunction against Idaho's law, but the Supreme Court stayed that injunction and set the case for briefing and argument, putting the law back into effect. The on-the-ground impact was stark. The largest hospital system had to airlift pregnant women in medical crisis out of Idaho about every other week so that they could get emergency care in neighboring states. This case was quite personal for me. I grew up in Idaho. In fact, the hospital airlifting pregnant women with emergency complications was the hospital where I was born. I was a junior volunteer at that hospital all through high school, and my best friend from high school currently works in the general counsel's office at that hospital. And I'm sure this prompts the question whether everyone from Idaho knows each other, and the answer is yeah, usually we do. To prepare for oral argument in the EMTALA case, I needed to understand the medical realities of treatments in emergency rooms. My Juris Doctor wasn't what the situation called for. I needed a real doctor. And luckily, I had one, an incredible government employee who was a practicing emergency room doctor, but also wore a hat as an official at HHS. This doctor worked tirelessly on the case for months. He read all the briefs. He listened to my moot courts. He drew me diagrams of how various health crises affect a patient's body. When we emailed him questions, he usually got back to us as soon as he walked out of the ER, sometimes at 6 a.m. after a full overnight shift. He flew into DC to attend the oral argument, and we made sure to reserve him a seat. He didn't expect anything from us in return for all of his effort. But his contributions were essential to my preparation, and it was a highlight of my work on that case to be able to surprise him with a quill after the argument. Strive to gather teammates like this in your life, and always remember to show them gratitude. And finally, rule number 5, keep fighting. In Moyle, the court issued a surprise decision lifting the stay of the preliminary injunction and dismissing the case as improvidently granted. That meant the court restored access to emergency treatment for pregnant women in Idaho. It wasn't a full victory, of course, but I count it as a win. I have to relish the wins and the sort of wins, because in the life of a litigator, loss is inevitable. I've had a lot of hard losses in my career. You will too. Even if you aren't a litigator, your life will bring other kinds of loss, of loved ones, relationships, career opportunities. Those losses can be gutting, and it's entirely natural to feel a profound sense of disappointment when the Supreme Court issues a decision that you disagree with and that has real stakes for the people of this nation. But here's what I'll say. About the very worst thing I think you can do in that situation is to give up and walk away. If you don't like the way a legal doctrine is shifting, you need to be the equal and opposite force that pulls the pendulum of the law back in a different direction. And you don't have to do that at the level of the Supreme Court. So much change happens from the bottom up. Focus on channeling your talents toward the public good in whatever form that might take, whether by developing a robust pro bono practice, working in public interest roles, or helping people through direct legal services. There are innumerable ways to use the privilege of your law school degree to build a society that lives up to your values. I can't wait to see what you do, class of 2025. Today, we're celebrating that you've checked off rule number 1 from your list. You've prepared yourself with a fine legal education. You're at your graduation having achieved a great thing. Everything's under control, you know what you're doing, and you know where you're going next. You're surrounded by your closest family and friends who love you and will cheer you on every step of the way. And that's a great feeling. Bask in that feeling. Then remember rules 2 through 5. Whatever your plans for the future, hold them with a loose grip and be flexible. Never compromise your integrity. Show gratitude to your family and friends who have helped make today possible for you. And no matter what life throws at you, keep the faith. Congratulations, class of 2025.
So now is a special moment because we get to watch our students walk across the stage, and as they do, they are ending one journey and beginning another. So it is an important moment, and for that I'm going to invite Assistant Dean Gordon Silverstein for the graduate program and Associate Dean Jennifer Surdy for the JDs to announce the names.
Dean Gerken, members of the faculty, distinguished guests, friends, and family, it is my distinct privilege and high honor to present to you candidates for advanced degrees in law. For the degree of Doctor of the Science of Law, Sergio Giuliani. Fernando Loaiza Jordan. Ana Beatriz Obalino. Orkan Abdulkarimli. Frederick Agaya Adongo. Tamar Benozir. Lara Fernanda Benitez. Stephanie Ching. Yuval Erez. Ari Gupta. Julius Mintus Hating. Henry Hatwell. Helena Hime Funari. Yun Hung Hung. Minky Huang. Herishka Jain. Frederico Omantin Yan. Samira Joanne Matthias. Zachary Tyler Nelson. Nobuki Okano. Carolina Palacios Sos. Lars Peterson. Vasily Rotaro. Amit Pal Chimasingh. Leo Tabergian. Emiliano Martin Vitaliani. Ziki Wang. Felipe Yaman Silva. And for the degree of Master of Studies in Law, Muhammad Ali Nasser. And Jeffrey Penny. Congratulations to you all.
Dean Gerken, members of the faculty, distinguished guests, friends, and family, it is with the utmost pleasure and such an honor to present to you the 2025 candidates for the Juris Doctor degree in law from Yale Law School. Aisha Edekunle. Sahil Agarwal. Nicholas Aldana. Sahil Amir Alim. Jessica Angel. Denise Araturk. Azad Marsal Azani. Kevin Baisden. John Paul Baisley. Amara Banks. Seth Richard Barrett. Mohammed Batal. Kevin Michael Boscheman. Kevin Gerard Chisholm II. Matthew Mylan Beck. Donovan Cole Bandana. Nicholas Adam Nathaniel Bernard. Drew Tyler Biesink. Raj Bahar Guv. Griffin Thomas Black. Alana Blanc. Chad Borgman. Jessica Ann Bucci. Connor Alexander Brashear. Beatrice Brown. Nathan Brown. Hillary Browning. Richard Sender Chang. Shella Malia Chowthry. D-Young Eleanor Shu. William James Clancy IV. Eamon Hanley Colburn. Taya Corona. Rosemary Mason Coscree. John Carl Crawford. Luke Matthew Cuomo. Tinuala Dada. Margot Marie Dara. John Alexander Davidson. Lucia de la Piolera. Harun Singh Du. Jennifer Dickler. Taiwo Dosamu. Jewel Drigo. Ciandra Rochelle Ellison. Grace Engelman. Mihal Eppelman. Abeli Aseka. Iveti Estepan. Dylan Farrell Bryan. Morgan Feldenkris. Stephen Patrick Ferguson. Andrea Danae Fleming. Esteban Flores. Jean-Luc Foster. Ashley Kane Fox. Frederick James Freeman Jr. Alex Friedman. Benjamin Friedman. Devin Alexander Froseth. Fiona Fernari. Rosella Ivana Gabrielle. Shreya Skundler. Philip Alexander Giannakropoulos. Natalie Elizabeth Geismer. Faven Gedahan. Amber Michaela Leanne Gibson. Riley Gordon. Isabel Grant. Hiba Kamal Grayson. Brittany Angelina Grego. Megan Lada Gupta. Simona Drithi Gupta. Fred Halbhuber. Megan Handow. Thomas Haynes. Remington Gray Hill. Chase Hinman. Jared Mitchell Hirschfield. Sarah Warman Hirschfield. Noah James Hoffman. Alexandra Catherine Holden. Jason Holmes. Jacqueline Huang. Ariel Chancier Tiana Hudson. Audrey Huynh. Philly Isaac. Amy Ishiwaka Kawa. Cook James. Denise Han Jimenez. Eric Kayondo Jemba. Alyssa Johnson. Malin Scott Jones. Adam Karras. Ryan Alexander Kellner. Adriana Maheen Khan. Corey Khan. Grace Ariana Kyer. E. Young Kim. Ho Jun Kim. Noah Kim. Chisato Kamura Kleinboomer. Elisa Brittany Kong. Caroline Rebecca Korndorfer. Jae Woo Kwok. Allura Damiana Nicole Landsberg. Eli Lee. Magdalene Marie Lemons. Romina Liloari. Matthew LaCastro. Sao Chi Long. Daniel Liu. Seamus McNeil. Nicholas Madden. Aaron Mack. Victoria Genevieve Maris. Jacob Andrew McDonald. Caledonia Aaron McQuilkin. Chloe Medina. Olivia Rose Mello. Maria Mendoza. Benjamin Menke. Shreya Minima Reddy. Yvette Moore. Chloe Dale Miller. Lillian Anna Moore Eisenberg. Pablo Moraga. Deja Raquel Moorhead. Sarah Myers. Darius Namazi. Jarek Nezapor. Derek Tyler Roy Nelson. Sharon Nunn. Trudel Sharon Perret. Amanda Perea. John Leon Newby Parton. Inbar Pear. Richard June Sung Pia. Courtney Perales Reyes. Maria de la Cruz Perales Sanchez. Aisha Lachey Kalina Phillips. Eva Claire Elliott Ping. Ryan Francis Pollock. Matt Lewis Post. Nadra Rahman. Krista Rasmussen. Nina Reddy. Otella Reggie Bean. Alyssa Rashar. Jeremy Chung Hoon Ree. Gabriella Rico. Andrew Holland Ricard. Emma Suzanne Roberts. Yadiel Rodriguez. Federico Reutman. Manuela Scarpa Saldana. Catherine Ann Salinas. Ryan Spencer Sandler. Margaret Sanicandro. Sophia Khadija Sayed. Eli Sher Zager. Emma Shore. Adam James Swab. Ethan Seidenberg. Yang Shao. Sarah Shapiro. Arun Sharma. Soledad Slowing Romero. Julie Sonnen. Elena Damaris Sokoloski. Paige Sorensen. Zachary Spitz. Neha Premi Srinivasan. Claire Catherine Hauser Staub. Claire Sullivan. Joe Sullivan Springhetti. Mary Sharkowitz. Arjun Talpalekar. Jordan David Thomas. Yehosef Talib Thomas. Brianna Thompson. Riley Samuel Tillett. Gabriella Torres Lorenzati. Rachel Troy. Paige Elizabeth Underwood. Rachel Vogel. Jacob Wagoner. Tyler Walls. Maggie Wong. Grace Watkins. Theodore William Watler. Sloan Austin Weiss. Nathan Williams. Peyton Williams. Jacob Reed Wers. David Theodore Wong. Henry Wu. Taylor Wartz. Catherine Shu. Stephanie Shui. Kevin Zhang Yang. Ding Yuan. Jenna Zhang. Kevin Zhang. So we sat the next couple at the end of their class as this ceremony coincides with another important milestone, the due date for their first child. Balin Victor Isaac Hernandez. Lorena Varshena Isaac Hernandez. And our final two candidates are also out of alphabetical order as they are dual degree students and have joined us straight off the stage from the School of Management ceremony. Mikhail Grant and Rachel Harmon. This concludes the Juris Doctor candidates. Please join me for one more round of applause for the Yale Law School class of 2025.
So this closes out our ceremony for today, but we have one more tradition in store for you, and it is my favorite from commencement. One of the things I found most moving coming from another school slightly up north is our faculty come to commencement, and they come to commencement so they can say goodbye to our beloved students, but also meet all of you. So we are going to gather over in the Baker Courtyard for a champagne reception and an opportunity for the faculty to get to meet the people who helped bring all of you here. So I'll ask the audience to remain seated until we've had a chance to process outward, and then we'll meet you over in Baker Hall. But with that, I just want to close. We just got to give these guys one more round of applause. So thank you all very much.